Your marriage is coming to an end, and with all of the emotion involved in divorce, it can get even tougher when you realize you have to divide all of the things you've worked hard to acquire over the years. Hi everybody, I'm Sean Ramirez, a divorce and custody attorney here at Frazier Ramirez Law in Albuquerque. New Mexico is one of the few community property states in the country. This idea of community property means that anything that's been acquired during the course of the marriage is assumed to belong to the community, meaning that each person has a 50% stake in it and it has to be divided as part of a divorce. Now, there are exceptions to this. For example, generally inheritances, gifts, and things acquired prior to the marriage are not considered community property. We call these things sole and separate property. All the other assets have to be divided, however. So what exactly are assets? Well, they include real property like a house, vehicles, bank accounts, investment accounts, retirement accounts, stocks, collections, and ownership interests in a business, to name just a few. Typically, these assets need to be equitably divided. Now, equitable doesn't necessarily mean equally. Some people might think that every asset has to be split down the middle, but that isn't really necessary. So let's look at an example of how this might work. Let's say Dick and Jane own a house that's worth $200,000 with a $180,000 mortgage, meaning it's worth about $20,000. There's $20,000 equity. Jane has a 401k that has $20,000 in it, and they have a savings account with $5,000. Dick also has a gun collection that's worth $5,000. They each own a vehicle that have been paid off and are worth about the same. So let's say that they agree that Dick will keep the house and be responsible for paying the mortgage. They also agree that Dick will keep his gun collection. So in this situation, he would be walking away with assets valuing $25,000. Under this situation, Jane would keep the entirety of her 401k and she would keep the savings account. She also is walking away with $25,000 in assets. So even though they aren't equally dividing each asset, they're still equitably dividing all of the assets. So let's say instead that Dick and Jane can't agree who will keep the house, so they instead decide to sell it and split the proceeds, so that they each will have some extra cash after the divorce. Dick will still keep his gun collection with $5,000, and they both split the $5,000 in the savings account. So at this point, Dick has $7,500 while Jane has her $20,000 in the 401k plus the $2,500 from the savings account. So to equitably divide the assets in this scenario, Jane will need to split the 401k, giving Dick $7,500 of the total $20,000 so that they each walk away with $15,000 plus whatever they got from the house. Of course, these are relatively easy examples and there can be a bit more nuance, but this should give you an idea of how the principles involved in dividing the assets in a divorce will actually work. Once again, this has been Sean Ramirez from Frazier and Ramirez Law.